Hello, my name is Sasha Struthers. I'm an employment and landlord-tenant attorney here in Los Angeles, and today I'm doing a brief video on disability discrimination. Before I go into it, you should subscribe to this channel and like this video prematurely without watching it, because why not? Just because you only live one life. Also, it's very easy and it'll make me feel better. In California, there are laws that prohibit employers from discriminating against employees based on the employee being disabled. Disabled falls into mental disability and physical disability. I'm not going to list them all out in this video, but they will be in the blog that corresponds with this. So you can read the list there. It's not an exhaustive list, but it's a pretty long list. If an employee has a mental disability, it has to affect a major life activity. One of those would be work. If they have a physical disability, it has to affect one or more major bodily systems and affect a major life activity. Also includes work. The most common thing I see employers do wrong, and when I represent an employee or represent an employer on the disability related case, is that the employer either knew or should have known that the employee had a disability, being that they could perceive or had reason to believe that the employee was disabled, or that the employee straight up told the employer that they were disabled, and the employer failed to adequately partake in what's called the good faith interactive process, which I have written a very extensive blog on how to partake in the good faith interactive process, which will also be linked in this blog if you want to go look at that. But the good faith interactive process is designed for the employer and the employee to go back and forth with each other, and places essentially the burden on the employer to try to make it feasible for the employee to maintain their job, either in the position that they are currently in or in another position within the company. This, of course, like anything ever, varies case by case, workplace by workplace, employee by employee, employer by employer. So there's no one size fits all criteria, but it does involve extensively back and forth with the employee. And the employers, if you're told that the employee has a disability and is requesting an accommodation, employers are not required to have an answer right there. So it's prudent of an employer to go back, research what the disability is, come up, with some sort of game plan idea, and really think about it, consult with an attorney, consult with if there's other managers in place, with other managers, supervisors, and go through an extensive process of trying to come up with a plan to present to the employee. You don't have to have it right on the spot. And what leaves employers vulnerable for lawsuits and what frustrates employees and leads employees to sue is the employer, dropping the ball and just not trying hard enough. And really the idea behind these laws to prevent disability discrimination is to keep people employed. That's the idea. So that's, when you approach it from that standpoint, that's why the state really wants you to partake in this process with the employee, and why it's encouraged that an employer and an employee, if they feel like that either one doesn't know or is not being helped adequately, get legal representation. And not always legal representation mean that someone has to get sued. Maybe it involves just coming to a resolution. But yes, you want to try to keep someone employed as much as possible. So should you have any questions about that, should you be an employer who is facing a disability lawsuit or claim, or if you're an employee who feels like you were wrongfully terminated because of your disability, or requesting reasonable accommodation, you may reach out to me. I do a free consultation and we can go over your options. Thank you.